Good evening, everyone. We'll begin in just a few seconds. We are allowing people to come into the room. Thank you so much for attending. We'll be with you in just a few seconds. Okay, well, welcome and good evening to our candidates forum. You could have been anywhere you wanted to, but you elected to be with us, and we greatly appreciate it. I do want to go over a few housekeeping rules with you. Judicial candidates are limited in discussing certain subjects. The Canaan 7 states, in part, that candidates should not make pledges or promises of conduct in office other than the faithful and impartial performance of the duties of the office, announce their views on disputed legal or political issues. The most controversial part of the rule is the portion prohibiting candidates from discussing their views on disputed legal or political issues. For example, Canaan 7 appears to prohibit a judicial candidate from expressing views on abortion or gun control. The reason for the prohibition is that judges must be apolitical arbiters of the law. They are not only expected to be impartial, but must also appear to be impartial. Therefore, judicial candidates must not make promises during campaigns about how they might rule or otherwise suggest that they have prejudged a case they have not yet heard. They must decide cases based on the law and facts presented in the courtroom, not on the basis of their personal views or prejudices. And I read this because as we gain the community's questions, we want to make sure that there are the type of questions that the justices can actually answer. And so as you come up with your questions, please utilize the Q&A section in our webinar or in the comment section on your on the Facebook page. But keep in mind, all questions must be objective, and they cannot be specific to any one case or any one political issue. With that being said, welcome. And I now want to introduce the president of this illustrious chapter of the Coalition of 100 Black Women Los Angeles chapter, the Dr. Carmen Downs.
You make me feel like I'm about to win a prize or something. Thank you, Chair Bacon. But welcome again this evening. My name is Dr. Carmen Downs. I'm the president of the National Coalition of 100 Black Women Los Angeles chapter. And for those attending this evening that may not be familiar with our organization, we have one very, very simple mission, and that is to advocate on behalf of Black women and girls and to promote their leadership development and gender equity in several key areas, and that is health, economic empowerment, and education. But we also have several core values, and one is racial and social justice, inclusion, collaboration, and gender equality. Our purpose, though, however, is to ensure that we take action on specific issues that are of local and national importance. And that, of course, is voting. We often say to ourselves, how can we make sure that we keep our community informed? How can we bring knowledge to our community? And tonight's event with our judicial candidates is one example of that. So I want to thank you all for joining, and especially our justices, who I'm sure have a very, very busy schedule. And with that, I believe I'm turning it over to our co-chair of public policy, Ms. Cambrisha Montgomery.
Well, good evening, you all. Thank you so much for joining us tonight as we have some questions for our candidates. So the first one is Justice Audrey Collins. So thank you so much, Justice Collins, for joining us tonight. It is a pleasure. I know that you have done so much work, but if you don't mind giving us a couple of minutes just to tell us about yourself and your work.
Okay. Don't like talking about myself very much, but here goes. I grew up near Philadelphia. I went to Howard University undergrad in the early 60s, where I met my husband, who was an LA native, which is how I ended up back here in LA. He went to LA High in Dorsey. He was in dental school. So after I graduated from Howard, then I went to American University, which is also in DC, and I got a master's there. And I taught for a little while at inner city schools. And then we returned to LA. And I worked at USC for a couple of years as the director of a student aid fund for low income and students of color. And then I went to UCLA Law School at the advanced age of 29, which was considered quite elderly at that time to be going to law school. I went into law school with one child, and I came out of law school with a second child. I had a daughter, my third year in law school. And I had clerked at the DA's office the second year of that summer, and I really found what I wanted to do, which was being there for victims of color. So I was accepted, I applied, joined the DA's office when John Van de Kamp was DA. And many people don't know this, Johnny Cochran was actually his assistant DA for 2 years. So when I joined the DA's office, Johnny Cochran was there. So I stayed there for 16 years, and I rose through the ranks and became a head deputy, and then an assistant bureau director, and then assistant DA when I applied for a position on the federal district court. This was President Clinton had just become president, and they had some vacancies, and I was fortunate enough to be appointed by President Clinton. And I served for 20 years on the district court, the federal judge, and I was chief judge of that court from 2009 to 2012. After 20 years there, I was interested in being on the appellate bench, and I also was interested in returning to state court where I had started. So I applied for the Court of Appeal, and I was appointed by Governor Jerry Brown to the Court of Appeal in 2014. So I have been here now for 8 years, and I'm now up on the retention ballot.
Okay. Well, you had a lot. That was very extensive. So thank you so much for sharing all of that with us. So this first question I have for you is a two-part question. And it is, do you believe the composition of juries adequately and fairly reflects society at large? Why or why not? And if not, what can we do to change this?
Okay, and there was also a question about driver's licenses. Actually, yes. The legislature has changed this. To answer your first question, the legislature has made a determination that the composition of juries in California was not, in fact, fair, and it did not adequately reflect society at large. And of course, you have, first of all, the pool. That's everybody who's called in. And just to answer your question, yes, they do use not only voter registration, but they also do use the driver's license list as a source of jurors. And that's the whole pool that's called in. But then you get to the part where the attorneys get to ask questions and strike some jurors, potential jurors. And the legislature has determined that this was not being done in a fair way. And that in fact, the attorneys were exercising these peremptory strikes to strike people of color in a very disproportionate way. And this was actually confirmed in a study, whitewashing the jury box. So what did the legislature do? They passed a law that actually just took effect in January of 2022 for criminal cases. It's not going to take effect until 2026 for civil. And from now on, what it means is that an attorney, if he or she strikes a juror for certain reasons, that's going to be presumptively invalid. And those reasons, and I'll try not to take too long, but I'll just give you some examples. Just because a person says, I've had a negative experience with law enforcement or the criminal legal system, that is no longer a valid reason, presumptively not valid. Or belief that law officers engage in racial profiling, or where you live, your neighborhood, or that you're getting state benefits, or that you are not a native English speaker. So those are going to be presumptively invalid reasons. And in order to still be able to strike that person, they're going to have to convince a judge that that's not really the reason that they did it, that they really believe or find that the juror can't be fair. And the judge now has to sustain an objection against a strike on those reasons if the court determines there's a likelihood that an objectively reasonable person would view that race or gender or sexual identity was really the reason behind it. Before this, there was kind of an intentional requirement. You had to show some intentionality, but now that's been replaced. And the judge is to sustain objections if a reasonable person would view that race or ethnicity or gender was really the reason behind it. And as I said, those are going to be considered presumptively invalid. So this is a new day. This is truly going to be a new day in jury selection. And it's too soon to say yet what is going to happen or what will be the effect or how many of those cases will actually make it up to us. And those cases make it up to the Court of Appeal. That's when we will be applying the law to the facts, which is what we do on the Court of Appeal, is apply the law. And the legislature has now given us that law, and we will be applying it to the facts when a case gets up to us.
So what are the pros and cons of using driver's license registration as a source of jurors?
Okay, actually, I think the question was, what are the problems or what are the pros and cons?
Yeah.
And to me, one of the things that I'm concerned with is access to the courts. And my colleagues share this same concern, I know. So in my view, that change, and that change, by the way, to use driver's licenses was only passed since 2015. Before then, undocumented people could not get a driver's license in California. And so the change was made to allow undocumented people to be able to get a California driver's license. And more recently, the change has been made to allow undocumented people to get California ID. So to me, anything that opens up or provides more access to the court for citizens and undocumented people is good. So allowing the use of driver's licenses and expanding driver's license eligibility to undocumented people, not only actually, I think, promotes safety, because now, of course, everybody has to have the insurance, but I think it means that people who couldn't be in a jury pool before now can be in a jury pool, and they can be obviously selected for that jury. And so to me, it opens up or provides greater access to the court. And so it's something the legislature did. So actually, my opinion doesn't really matter. As I said, we interpret the law. Our opinions don't matter. But I do think that it has the salutary effect of expanding access to the court. After all, many undocumented people are witnesses. Many undocumented people are victims, and undocumented people are also defendants. So in order to have a jury of your peers, then the idea would be that undocumented people should be eligible. And if that was at least that was the intent of the legislature, to open that up so that undocumented people would have an opportunity to be one of a jury of peers.
Okay, thank you so much for that. And second question, what factors are considered in granting and setting bail amounts for defendants? And what do you believe is the primary consideration?
Actually, this also has been determined by the legislature. As you know from hearing the introduction, we don't, as judges, use our personal opinions here. So this area is a really hot area, bail reform. And factors are set out by law, but there have been many efforts recently to reform this area and get rid of sort of cash bail. And these areas, this has been tried in the legislature, and we also have a major California Supreme Court case on it. But the California Constitution, which of course we must follow, and we take an oath to follow the California Constitution and the US Constitution, added Marsy's Law. And I don't know if you remember, but it was called Marsy's Law. It was added in 2008. And it says that in order to preserve and protect a victim's rights to justice, a victim shall be entitled to have the safety of the victim and the victim's family considered in fixing the amount of bail and release conditions. And if there's going to be a bail reduction or denial, then the judge has to also take into account the protection of the public, safety of the victim, seriousness of the offense charged, previous criminal record of the defendant, and the probability of that person appearing at the trial or hearing. Also in the Penal Code, which of course is the law we have to follow. Penal Code Section 1275A1 says, in setting or reducing bail or denying bail, a judge shall take into consideration the protection of the public, seriousness of the offense, previous criminal record of the defendant, and the probability of his or her appearing at trial. So then in 2017, our Chief Justice, Kantil Sakaue, determined she did not think, or her group that she appointed said cash bail system is just not fair, because it puts the ability to get out basically on how much money you have. It's basing your liberty on financial resources. And that group wanted to adopt a risk-based pretrial assessment group. We would have risk assessments. And the legislature said, yes, that sounds like a good idea. The legislature went with that idea of risk assessments instead of cash bail. However, various groups, and you'd be surprised at the groups that oppose that, because they're groups that usually are against each other. The bail industry obviously says this is a threat to us if they get rid of cash bail. So we're not for this new system. But the ACLU was against it too. And you might ask, well, why would the ACLU be against something that gets rid of cash bail? The ACLU was wary of this idea of risk assessments, which were supposed to be formulated or promulgated by a pretrial services unit that didn't even exist yet. But some of the factors would have included, whether a person had prior criminal history, race, age, sex. And the ACLU said, basically, we don't want to get rid of one bad system that determines bail based on what you can afford with another potentially bad system that could have factors that disadvantage people of color by looking at these kinds of factors and artificial intelligence. So there was a ballot measure in November 2020, which proposed to end cash bail and implement the risk assessment system. It failed because, as I said, all of these groups opposed it and feared that it could actually either the bail industry feel it would kill them, and the ACLU and other groups, some other groups said, we're just afraid this is going to be used against people of color. That was November 2020. 4 months later, in March 2021, the California Supreme Court decided a major case, a major bail case called In re Humphrey. And that case said common practice of conditioning freedom on whether you can afford bail is unconstitutional, because often there are other conditions of release, electronic monitoring, checking in with your pretrial person, community housing, can protect the public and victim safety just as well. So we hold that if you do need a financial condition, if those things won't work, you still have to consider the arrestee's ability to pay the amount of bail. And you can't detain an arrestee just because the arrestee lacks the resources to post bail. Now, I do want to say that there are cases that are really considered, my light went out. Violence, when there's violence involved or great harm to a victim, you still, of course, can detain. But if that is not the case, then you must consider the ability to pay. Excuse me, I need to stand up because this is movement controlled, and that's why my light went out. So I'll be right back. Let me just stand up for a second. Got it. Okay, I'm back. The one disadvantage here. So Humphrey is still too new for there to have been too many cases construing it. And for the most part, bail is decided also by the trial court, not by us on the Court of Appeal. That's not to say that we never ever get these issues, because if a person feels that there's been a violation of the California Supreme Court law set down in Humphrey, they can ask for a writ of habeas corpus, and they can ask the justices here on the Court of Appeal to take a look at it. It can be used to challenge detention without bail. You also should know there was a zero bail policy in effect for a little while, and that was during COVID. That was not part of this whole debate on cash bail, but that zero bail policy, which was for low-level offenders, that now is over as of June 30th, 2022. And the legislature has continued its efforts to reform the system. And the latest effort failed on the last day of the legislative system, the legislative session, it would have barred suspects released pretrial from being charged for their ankle monitors. And also it would have said that if charges aren't filed within 60 days of arrest, you would get your bail premium back because you have to pay 10% of the bail that's set. So that was, they thought, a good idea, but it did not pass the legislature, but I assume they will be.
So I don't mean to cut you short, but for the sake of time, I can ask you one more question.
Okay.
Who are your judicial role models and why? And this will be your final question.
Okay, and I'll just list two, one from the federal and one from the court system, since I was in both systems. Federal, Constance Baker Motley. She was the first Black woman to serve as a federal judge in New York, Southern District of New York. She went to Fisk, another Black school. Of course, I'm like Howard, yay, Fisk, yay. She was the first Black woman actually to argue a case before the US Supreme Court before she became a judge. She argued 10-1-9 immediately. She was the chief tactician of the civil rights movement, especially the James Meredith case, to seek and get his admission to University of Mississippi. And she actually became the first, as I said, Black woman to serve as a federal judge. So she is a role model for, I think, all women judges, and certainly in the federal system. And then on the state, Vano Spencer, who I was fortunate enough to know, she was the third Black woman to pass the California bar exam. She was California's first Black woman judge. She went from Uni Court to Superior Court and then the Court of Appeal. She founded Black Women Lawyers and founded also the National Association of Women Judges with Joan Dempsey Klein. And one of my favorite memories is coming here to have tea with her. One of my other role models, Judge Consuelo Marshall, the first Black woman appointed to the district court here in LA, brought me down to have tea with her, and she encouraged me to apply for the Court of Appeal. And believe me, when you had tea with Justice Spencer, you didn't have tea in a paper cup. You had tea on her china tea set. That was the most elegant tea set I have ever seen in my life. And she had that right here in Chambers. And I was honored to have tea with her and get to know her.
Well, thank you so much for sharing that. And I'm going to turn it over to our Public Policy Chair, Monique Bacon, for questions from the audience.
Thank you, Justice Collins, and we appreciate you so much. And there's so much information that we know that you wanted to share. And unfortunately, we are under a little time constraint. So I can really only ask you one question before we bring on Justice John Shepherd Wiley. But thank you so much for all of your answers and your time. But if you observed a party in your courtroom being poorly represented by an unprepared or ineffective lawyer, how would you handle that situation? If you could just answer that, if you can, within 2 minutes.
Okay. If it's just poorly represented, or, in my opinion, that person could do better, there's really not much that can be done. An individual has a right to counsel and to his or her own counsel. And, we can't leap in and say, your attorney's terrible. You made a mistake and you should have picked somebody else. Mm-hmm. On the other hand, if it rises to the level of the attorney doing something that is actually improper, a violation of the law, a violation of even the rules of civility, we do have, if it's actually something that violates the rules of law, that they can be referred. They can actually be referred to the Office of the Chief Trial Counsel of the State Bar of California. And that is what I would do if it rose to that level. And of course, in the trial court, usually what happens also, if a person is actually contemptuous in front of the court, there is a remedy for that also, contempt. But here, as I said, if it actually is a violation, rises to the level of violation of the rule of ethics or law, we can refer that person to the Office of the State Bar Chief Trial Counsel.
Well, thank you so much for that answer. And again, we want to mention that we are a nonpartisan organization, but it does not stop us from wishing you well. And with that being said, we thank you so much, Justice Collins, for taking the time out of your day to join us during this candidates forum. And again, we wish you well, and you're free to stay on. And with that, I want to bring back Cambrisha, our moderator for the evening. And Cambrisha, you can go ahead and introduce the next Justice John Shepherd Wiley Jr.
All right, so thank you so much, Monique. And I would like to introduce Justice John Shepherd Wiley Jr. How are you tonight? Oh, you're muted.
I'm very honored to be here, especially in the company of two spectacular judges. I just wish you hadn't put me after Justice Collins. It's, it's a rule of show business that you shouldn't have to follow and act like that.
Well, we are glad that you are here. And just for the participants here, or the audience who is here, can you just tell us a little bit about yourself in a couple of minutes?
Sure. Well, let me tell you something about Justice Collins before I get to me. She left a lot out, and it's one of the extremely endearing qualities that she has always had in her professional career. When she was at UCLA Law School, she didn't just graduate. She was Order of the Coif, which means top 10% of the class. In other words, she was a straight A student. She was on the Law Review, which is a big honor. When she was appointed to the United States District Court by the president, she was confirmed by the United States Senate. Now, anybody who's watched Senate hearings about judges knows it's a cat fight. It's a dog fight. It's World War III. It's terribly divisive, and there's all kinds of attacks. The Senate overwhelmingly, by a super majority, enthusiastically approved then District Judge Collins after going through every corner of her record. That just doesn't happen very much.
Well, I have to interrupt and say that if I did well in my hearings, it was because of the current speaker, John Wiley.
Right.
Yeah, no, really.
I was pulling all the strings.
I didn't know how to prepare because I'd been from state court, and I went to UCLA, my law school, and he was there. And another professor said, ask him, because he had worked for the Senate Judiciary Committee. And he was so helpful to me. He didn't know me at all, never met him. And he provided me with the background. He provided me with transcripts of previous hearings. So if I did well in my hearing before the Senate Judiciary Committee, this is the person that I have and have always acknowledged he was responsible for it. He is just a fabulous lawyer and has been a great justice. And that's the kind of person he is. He'll go out of his way for you when he doesn't even know who you are to help you. So thank you again in front of this group.
Well, thank you both for sharing that. So Justice Wiley, can we hear about you?
So I control everything that happens in the United States Senate. I'm glad that's finally realized. I have this power behind the throne. No, seriously, I have gone to California public schools all my life. In the San Jose area, I went to public high school. Then for undergraduate and graduate work, I was at the University of California. I worked for a couple of judges as a law clerk, and then went to work at UCLA Law School, where I got tenure, and but missed actually practicing law. So I took a leave of absence and went to the U.S. Attorney's Office and was a federal prosecutor. Then came back to UCLA, and then was appointed to the trial court, to the Superior Court, 20 years ago. So I haven't been a judge with as much experience as Justice Collins, but I guess it's a disguised way of saying I'm just very old. I've been now doing this job for 20 years. So that's my background.
Okay, so I know Justice Collins gave us a lot of information on the legislation that changed, but I do want to see if you wanted to add anything to the first question of, do you believe the composition of juries adequately and fairly reflects society at large? So is there anything you want to add to what Justice Collins brought now that the legislation has changed?
Absolutely, yeah. I want to echo and underline her theme about how important, how American it is to ensure that juries reflect our community accurately and fully. This is not some new idea. This has been a concern of Americans before there was America. This was a concern of the colonists in pre-revolutionary days. There was this trial, recall the trial of John Peter Zenger, who was a colonist who wrote criticism of the British royal government, which then prosecuted him for criticizing them, saying, they said that was seditious libel, you can't make fun of us. And Zenger was put on trial. And fortunately for him, it was a jury trial, and the jurors were Americans. And his lawyer said, members of the jury, use your common sense. Zenger's telling the truth about the British. That's not seditious libel. He was acquitted. And that sparked a lot of anger from the British government. And they tried to abolish jury trials for colonists by forcing everybody into Admiralty Court where there are no juries. And the colonists fought back with a protest to parliaments, including a phrase, no taxation without representation, and saying, we demand the right to trial by jury, and the jury has got to reflect our community. We've got to be able to talk to people like us who can use their common sense, use their life experience to evaluate the case in its legal technicalities and in its broad contours as well. This has always been an American concern, but of course, it's always been a big American problem too. Because, for example, there were terrible examples in the Jim Crow South of how Blacks were fenced out of jury duty, just not allowed on juries at all. And even before Brown versus Board of Education in 1954, the United States Supreme Court declared and enforced a constitutional right to a representative jury. So these cases go back to the 40s, and they're still alive today. There is an opinion from 2017, I believe, a unanimous opinion from our state Supreme Court that evaluated the Contra Costa jury pool against a charge by a defendant, Mr. Enrique, I think his name was, or Enriquez, I guess it is. Justice Leandra Kruger, who is a bright shining star of our state judiciary, wrote an opinion for the California Supreme Court unanimously, evaluating whether that jury system was unfairly excluding Blacks from the jury pool. But as Justice Collins said, it's not really the composition of the jury pool where the big controversy has been in recent years. It's more the use of these peremptory challenges as opposed to challenges for cause. Now, as she explained, a peremptory challenge is a challenge that a trial lawyer can make to strike a juror for no reason. Well, what's really going on there? The fear is that this is implicit racism, or maybe just explicit racism. And the trial lawyer strikes a juror for a reason that may not be valid, that may be unconstitutional. This is the so-called Batson-Wheeler problem. Those are the Supreme Court cases, Batson and Wheeler. And it's a big issue for trial judges, and it always has been, because trial lawyers want to get rid of jurors that they think are bad jurors for their side. And who is that exactly? Well, the fear has been there's a lot of improper decision-making by those trial lawyers If I'm going on too long, Ms. Montgomery, don't hesitate to let me know. But this is a big topic, and Justice Collins was so right to emphasize this new legislation, which has yet to hit the courts of appeal. It's just effective in trial courts at the beginning of this year. So it's working its way through the system. I'm sure these cases are coming. But the goal of this legislation, this brand new legislation, was to clamp down on peremptory challenges to try to eliminate implicit bias. Now, will it be successful? Well, we'll see. Time will tell. Courts of appeal will be evaluating this. The Supreme Court will be evaluating this. The legislature will keep evaluating this. But the thing to know is the legislature is tuned into this and is active and is not bashful about taking action. And this is a pretty aggressive new piece of legislation. A lot of it's had a big impact on the trial bar. And Justice Collins mentioned that it's effective this year. The legislation, I think, was passed a couple of years ago, and Governor Newsom signed it. And it took a while to become effective in criminal cases because it was going to be a big change, and everybody had to get ready for it and figure out, be prepared. There's some new rules, and it's even more delayed in civil cases, but it's coming, and it's going to make a big change, possibly. But it shows that the California legislature is active here.
All right, and so I'm going to ask you a different question now. So what are the issues regarding alternate sentences for nonviolent offenders?
Well, that is an excellent follow-on question for the last topic, because once again, the California legislature has been tremendously active in the area of adjusting sentences and changing rules about incarceration. And much of the motivation here has been a fear of a concern about mass incarceration or over incarceration that's familiar to everyone. So there are really more statutes than I can count that have, some of a big batch of them came into effect this year that adjust sentences and allow people who are incarcerated presently to petition courts to be resentenced or to have their sentence reformulated in different ways. Sometimes it's not just a sentencing change. Sometimes it's a change in the actual crime itself. There's a type of homicide doctrine, the felony murder doctrine, that there's a particular statute that deals with that. The complexities of these statutes are many, and I'm sure Justice Collins and Justice Baker will agree with me that we see a lot of cases like this now. Unsurprisingly, when people who are incarcerated find out there's a possible way of maybe decreasing their sentence, they jump at it. So there's been a lot of petitions of this sort, and these are working their way through court. But again, what I want to stress is that legislature, it works. There's a popular concern about this issue, this series of issues, and the legislature is responding in many different ways. I hope that's responsive.
No, that's a great answer. Thank you so much for that. I am going to turn it over to our chair, Monique. After I ask you just the very first part of question 2, if you want to piggyback off of Judge Collins, which is what factors are considered in granting and setting bail amounts for defendants?
Well, I will follow her excellent statement of the issues. Her extensive background in federal court gave her a unusual and valuable perspective when coming to state court on these issues, because strangely, the federal bail system is very different than the state bail system. The federal system, when I worked as a federal prosecutor, there were really 2 issues at a bail hearing. Is the person a danger to others? And is the person a flight risk? And if either of those things is true, then bail should be set. No bail should be set. They shouldn't be allowed out if they're going to go, kill the domestic violence victim after they just beat her up last time. If the prosecution can show that, then that's a reason not to release the person on bail. The same thing is if they're a flight risk. If they're a billionaire and they have a bunch of private jets waiting at the airport, you're not going to let that person out no matter how much money they put up. So those are the two factors: flight risk, danger to others. Now, if those factors are not present, then why is the person in custody? Of course, you want them to come back to court. People are reluctant to do that. So you've got to set some kind of bail, but the main consideration there is ability to pay. You don't just set a flat amount, $1 million, $500,000. You evaluate the person's financial situation, and there's a lot of ways to do this. And then the judicial officer who's making the bail determination tries to set an affordable level of bail that will create an incentive for that defendant to come back to court. So I hope that's responsive. Two factors, otherwise affordable bail.
And last, really, really quick, we have a little bit more time with you. Can you name one judicial role model and why?
Audrey Collins. I'm serious. No, I've known Judge, now Justice Collins, since the early 90s. It's so rare to find such a spectacular judicial talent who combines such experience and such wisdom with such humility and such grace. I wish more judges were like her. I wish I was like that.
Oh, well, I really appreciate that answer, and I'm sure Judge Collins does as well. So I'm going to turn it over to our chair, Monique, so she can ask you a question from the audience.
Thank you, Justice Wiley, so much. We only have time really for just one question, and that is, if you became aware of an ethical conduct on the part of a trial advocate in a case in which you're presiding, how would you handle it?
That's an excellent question. Justice Collins is right. One response is to report that lawyer to the bar. And every year, the state bar sends all judges a letter saying, we're the trial counsel, here's our phone number, call us or email us if there's a problem. And I think not frequently, happily, but it does happen where we report a lawyer to the bar, and that's a big deal. That's basically threatening the lawyer with her or his livelihood,
right,
or some kind of sanction. There's other ways to affect bad behavior by lawyers that falls short of some sort of criminality. If the lawyer's just being a real jerk, can you imagine that, a lawyer being a jerk? Uncivil conduct. Judges very often are asked to award attorney fees. And one way to get a lawyer's attention is through attorney fees. So if one component of attorney fees is civility, and you get a discount on your fees for incivility, that can affect behavior. And in fact, there's opinions to that effect, fairly recent opinions that I think, I hope, point in the right direction, because this is a problem. We want lawyers, we would like fewer lawyer jokes.
Right. Thank you so much, Justice Wiley, for your time. And as I have mentioned before, and I have to mention again, we are a nonpartisan organization, but as we shared with Justice Collins, we wish you well as well for this election. And and thank you so much again for participating, because you all could have been anywhere tonight and you elected to spend your time with us, and we don't take it lightly. We greatly appreciate your time, Justice Wiley, as well. And you feel free to hang on if you want, but you're also free to go if you like to. Before we bring on Justice Baker, I forgot to mention to you all that, well, in my sample ballot booklet, you can find the list of these justices on page, well, it says LA 861-019. I'm assuming that's page 19. At least that's in my book. It might be different in your book, but all of the justices are listed in that book. And with that, we would like to bring on our last justice of the evening, followed by our spokesperson from La Defensa, Justice Baker. Welcome, Justice Baker.
Thank you. Can you hear me all right?
Absolutely.
Good evening, Justice Baker. How are you?
Good evening. I know we're doing this virtually, but I still envision a lot of strong good evenings coming back at me as if we were doing this in person. So I'm glad to be here. I think it's great that you're doing a nonpartisan voter education event.
All right, we appreciate you taking your time out on this Wednesday to join us. So if you would please be so kind to just give us a couple of minutes and tell us a little bit about yourself.
Sure. And if it's all right, I know some things have already been covered, but I'll spend just a very quick second at the end talking a little bit about the court on which I sit, the Court of Appeal. So going in chronological order, I went to Stanford for college. I went to Yale for law school. Right after law school, I worked for a federal judge in Pasadena, Dorothy Nelson. And if I get the role model question, you may hear that name again, Dorothy Nelson. And then after that, I worked at a small firm in LA doing public interest and public policy work. And then following that, I was assistant US attorney for 5 years. Then I went to Washington, DC, where I worked at the Justice Department for 3 years doing legal policy work. And then for about 2 years, I was special assistant to the president and associate counsel to the president in the Obama administration. And after that, I was appointed by Jerry Brown to the current job in 2015. So I've been on the Court of Appeal for now, I guess, a little over 7 years, which is interesting to say, and reflecting that it has been 7 years. Just by way of very quick background, and I apologize if I'm telling you something you already know, but our court is a court of appeal, and that's not often portrayed in the TV and movies. There are no juries in our court. Very rarely are the parties in our court, because what happens is there is some sort of judicial decision or jury decision that happens before a case gets to the Court of Appeal. So we're a court of review. We're not a trial court. We're not a court in the first instance. And so that sort of affects how we go about doing our jobs, but we're also a court of general jurisdiction. We hear everything: juvenile cases, criminal cases, civil cases, family cases, probate cases. So it's a really wide-ranging docket, but again, it's a court of review. Something has happened and somebody comes to us saying, look, we think there was an error here and this needs to be done again, or this needs to go back. And that's what we do, is we review.
Okay, well, thank you for sharing that, because now I'm only going to ask you the last part of the first question, if you want to add anything to it, since you work in a court of appeals where juries are not a part of that. So what do you think the pros and cons of using driver's license registration as a source for jurors?
So it's interesting. I can say a little bit more, which is the California Supreme Court commissioned a working group to study some of these jury representation issues. And they actually issued a report in July of this year, and it's available online. And if you're interested in these jury issues, I recommend it. It's not super dense, right? I mean, I could see, sometimes we get into the case law in an event like this, and, everybody's, sort of leans back a little bit. And, hold on a second, but it's pretty accessible. And one of the things it talks about is, the fact that courts do not do a particularly good job of collecting demographic data about jurors. And so if you're not collecting the data, it's very difficult to come to a view on whether juries are appropriately representative of the communities that they're drawn from. And so there are recommendations for reform in this report, and one of them is data collection. But to get to your specific question, which is about driver's licenses, that question in large part has been determined by the legislature. So there is something called the Trial Jury Selection and Management Act. It's found in the Code of Civil Procedure. And that act specifically identifies registered voter lists and licensed drivers lists as appropriate source lists to send out summonses for jury service. Interestingly enough, the law changed a little bit at the beginning of this year, and maybe there's a little bit more flexibility than there was before, but in some ways, the legislature has answered your question and has said that this is how we're going to do jury selection, or at least sending out summonses for jury service. And so to the extent that anybody has a view as to whether that's a good way or a bad way, I think that's the kind of thing that has to be addressed to the political branches of government. When I say that, I mean the governor, the legislature, your representatives, because as courts, our job is to enforce the law.
Okay, I appreciate that. So moving on to the second one, do you want to add anything to the factors considered in granting and setting bail for defendants?
I will. I warn you, this will be a little bit dense at the beginning, but I'll try to make it a little
Okay.
accessible at the end. Under our state constitution and statutes, there are certain things that courts must consider. And that includes protection of the public and the victim of the crime, the seriousness of the charged offense, any previous criminal record of the defendant, and his or her history of compliance with court orders, and the likelihood that the defendant will appear at future court proceedings. So those are the factors, and those are the factors because the California Constitution and California statutes say those are the factors. Now, there has been discussion, and I don't need to repeat it. You all have been super patient and engaged so far, so I'm not going to do that, but I will say, and this goes back to something I said at the beginning, there's something in the state called the Judicial Council, and they do a lot of work that's court-related, but is not strictly litigation. And they issued a report in 2017 calling cash bail unsafe and unfair. And this was a working group that was commissioned by the Chief Justice of California. And so to the extent that folks have a view on how bail should be determined and how the process should work, this is again an opportunity for engagement. Right now, there is an invitation for public comment about what the bail schedule should be for certain misdemeanor and infraction offenses. And that's public comment. That's everybody on this screen. If you have a view, that is your chance to be heard. So it's not so much that everything about courts, you have to be a litigant. There are a number of ways to get engaged in some of these issues, particularly with respect to the Judicial Council's work, to the extent that you or anyone else finds them interesting.
Okay, and so what are the issues regarding alternate sentences for nonviolent offenders?
So Justice Wiley and Justice Collins, I may have missed the first part of her answer on this, but I know Justice Wiley talked about it. And this is an area where the legislature and the voters have been quite active. In 2016, voters passed Proposition 57. And what that proposition said is we're going to give early parole consideration, not early parole. In other words, you're not guaranteed to get it, but you're going to get early parole consideration for nonviolent offenders after they've served the principal term for their sentence. There's been a lot of statutes in the past several years expanding diversion programs, diversion for mental health, diversion for members of the military and veterans. And just recently, and when I say recently, I mean this is something signed by the governor at the end of last month. The legislature passed another bill, Assembly Bill 2167, and that bill says it's the legislature's intent that trial courts dispose of criminal cases using the least restrictive means available, and that they consider alternatives to incarceration. So that's what the legislature has said courts should be doing. And it's an expression of legislative intent that I think courts will take seriously. Beyond that, these issues, whether it's diversion or recent legislation, do come before the courts of appeal and may come before my court again in the future. And so any opinion I write is going to follow governing law and consider the particular facts presented in any case that comes before me.
Okay, and last question, who are your judicial role models and why?
Sure, this is great. See, I get to say more than one.
Because your
Justice
answer
Wiley
is a little
was limited to
shorter,
one, but I can sort of sneak at least a second one in there. We'll see, but I'll be quick. I know you've been super patient. So Dorothy Nelson, the judge I clerked for right out of law school, is a role model of mine. And in many respects, she's a legal pioneer. She was the first female dean of an accredited law school, USC. And as anybody will tell you, she is unfailingly thoughtful and unfailingly kind. And as it turns out, those are two really important qualities for somebody who has the job that I have and has to come to decisions, not just myself, but with a panel of two other people. If we had more time, I would tell you an interesting story about how I learned the importance of kindness from Judge Nelson, but I'm going to skip that. And I'm just going to mention.
Can you make it like a minute? Can you give us like a cliff note of the story?
I'll give you a very condensed version.
Okay.
It so happened that in talking with Judge Nelson soon after my clerkship, and remember, I'm just out of law school. And it turned out that she had a disagreement with the other people who were hearing the case with her. And so she asked me to work with her on preparing a dissenting opinion. And so me, the fresh, eager young law student, I go back to my computer and I type something up, identifying all the areas of agreement. And I'm pretty proud of this thing. And I drop it off on her desk and I say, here you go, Judge Nelson, here's the draft, which you can consider. And the first thing she said when she walked back into my office is, now, these people are my friends. And that sort of crystallized for me that it's not about scoring points. It's not about, trying to point out every little thing that's wrong. You have to have relationships when you decide cases as a group. And being thoughtful and being kind is really important. And it's something that I try to do in my own time working on the Court of Appeal. So having said that, that's a long first one. So I'm just going to mention two other names and I'll be super quick. Robert Jackson, US Supreme Court Justice, and Charles Hamilton Houston, who essentially revamped Howard Law School from what it was before and was the first general counsel at the NAACP. And that, as everybody knows, produced people like Thurgood Marshall, Spotswood Robinson, Jack Greenberg, Constance Baker Motley, who Justice Collins referred to. So those are three of mine. And thank you for the opportunity to get in slightly more than one.
All right, I really appreciate your time. I'm going to turn it over to our chair, Monique, so that way she can ask you a question from the audience.
Sure.
Thank you so much again, Justice Baker, for attending. And I'm going to have to repeat this again because, people come in and out of our sessions that we are a nonpartisan organization. And with that being said, we wish you as well as the other justices well during this election. But I do have time for one.
Sure.
Before I say that, I also want to say thank you all for taking us to school. I have been taking notes. Every justice that has been on. So I'm paying attention. I might not be looking at you, but I'm paying attention, but I'm steadily taking notes because this has been truly a learning lesson, I would say, for all of us. And so again, we thank you so much. But here's your question. And it's kind of like a three-part. Do you believe that voluntary, professional, and community service is a necessary commitment for persons holding a position such as yours? I'll just leave it at that.
So I suppose it depends a little bit about what you mean when you say volunteering and community service. In some ways, I'll talk a little bit, and if this wasn't what you're getting at, you can tell me, and I'll try to change. But in some ways, the job is public service, right? That's sort of why we get into this business. But I think the idea of the question is, are judges part of the larger community in which they work? And I think the answer to that is absolutely yes. And that's part of the reason why I think participating in a nonpartisan voter education event like yours, and kudos again to you and everyone else for taking the time to put this on, is worthwhile. Now, having said that, there are certain constraints on judges as far as what we can do and what we can say, and I try to take those very seriously. Because I think it's important that everybody knows that if I'm a judge on their appeal, that they're going to get a fair shake. I'm going to look at the issues on both sides. So it's absolutely true that we are a part of the community within certain constraints. And whether it's an event like this, or whether it's going to talk with law students and judge moot court competitions, which I do frequently, and certainly before the pandemic, I don't think I ever turned one down unless I had a scheduling conflict. The pandemic and some things scrambled a little bit of that for everybody, but I think there is an obligation for folks to engage to the extent that they're able in the job.
You did actually answer that question, because oftentimes when it comes to the voting season, and then we'll be done on the voting season, we have page or two of judges, justices, and honestly, it's like, I have no idea who this person is. I haven't seen this person. And we know that it's a yes or no vote. I mean, we got all that, but it's like, who are they? So we're glad that we were able to do this, and we do plan on doing, more when the time comes for other justices or judges to, come before the community. But you did hit the nail on the head, because I do think it is important that we have a face to a name when we're saying a yes or no, and being able to just understand, your platform and et cetera. And so with that being said, I wish we had more time, because we all enjoyed meeting you all and seeing you all. And again, we appreciate your time so much. On behalf of our organization, we just thank you for being here. As I mentioned to the other justices, you're welcome to stay on if you like, or if you have to leave, we understand too. So you can hear a final word from our president at the end. But thank you so much, Justice Baker. And with that, we are going to have, okay, so I took my notes. Next, we have a beautiful representative from La Defensa, and her name is Titilayo Rasaki. Thank you so much for being here, and take it away.
Thank you, Monique, and thank you for having me. My name is Titilayo Rasaki. I use she, her pronouns. I'm a policy and campaign strategist with La Defensa, and I'm going to share my screen to share my slides. Excuse anything you see on my situation. But yes, okay with that. Okay, so I'm here to have a conversation with you all about our work at La Defensa. We're a community-based organization based in Los Angeles County, really working to uplift judicial accountability and educate voters, particularly around the LA County Superior Court, and as well as the retention elections that are happening at the state level. So just a little bit more about La Defensa, our work. We are working to decarcerate the largest jail, the county with the largest jail population in the US, the LA County jail system. And we're doing that through multiple fronts, right? We're working at the grassroots community level, educating folks, really empowering folks to, approach the legislators, really write bills, and really bring that to the Capitol and really try to push those forward. We work within the community, again, in terms of community education around the judiciary, how it functions, and how it is that folks can get involved in terms of holding their judges accountable and engaging in local budgets, and all basically that works in terms of understanding the social fabric and how it is that we try to shift power and really help people understand how it is that democracy functions at the local level. a little bit about me. I am a lawyer by training. I attended Harvard Law School and graduated in 2017. And in the course of my career, have organized. I've been a corporate attorney. I've been doing antitrust law. That was not my jam. You know, my background as a person who's been directly impacted by mass incarceration, having had lost my family's home to having to grapple with coming up with cash money bail, you know, when I was going to law school, that really grounded a lot of my experiences and understanding how it is that, you know, the law moves in our communities and how it is that we try to bring power back to the community. And so my vengeance for all the student loans that Biden and them have not canceled is really democratizing the law that I've gained and the legal knowledge that I gained. And in our community organizing, Justice Collins and the other justices were covering a lot of the organizing that has happened since 2019 around cash money bail, and our community organization and our coalition of organizations were truly at the forefront of that fight, and we're at the forefront of making sure that Prop 25 failed in LA County. Why? A lot of what Justice Collins covered in terms of the risks to our community members of risk assessments in particular, right? Because we understood that the issue with cash bail is about pre-trial detention, right? Somebody being held pre-trial without having had their day in court and being held pre-trial and losing their home, losing the possibility of losing their children. I've experienced that firsthand and understood that the way that it's working, and the organizations that we work with, directly impacted folks, went to the legislature and were fighting to, you know, end cash money bail. But the response that we got, like often from our experiences and our debriefs with our legislators at the behest of judges, right, was this new system, this new kind of iteration of pretrial detention by, you know, using risk assessments as a means of determining whether or not somebody should stay incarcerated. And in our experience and our research, we understood that that was really codifying and really creating an algorithm based on and using data from a racist you know, structure of policing and a racist structure of mass incarceration, right? And so, you know, using factors like number of arrests, using factors like, you know, your zip code, using other risk factors like age, you know, really just continue to have the risk of making sure that Black and Brown folks would remain incarcerated pre-trial and would not have even the release of pre-trial release through cash bail, right? So we understand that this is really hard, right? I have a check here. Oh, it's hard because of the background. In May 2020, I paid $200,000 in cash, and I framed this because that is the amount of money I walked into the LA County Sheriff's Office to bail out a Black mom for Mother's Day, and I was refused, right? Because you can't buy the freedom of a human being with cash, and apparently you need a cashier's check, right? So we as community organizers have been really working and seeing how it is that the decisions of judges really land within our community, and how it is that we community members are able to take power back and really shed light upon what's happening and what the direct everyday experiences that are reverberating from the decisions of judges. And so like La Defensa, you know, really seeing that judges, particularly the Judicial Council, right? Because again, understanding that yes, the Judicial Council operates as the policymaking body of the courts, it also has this kind of quasi-legislative function that is really scary, right? Because legislators in our communities who are, you know, being approached by constituents to pass legislation that we believe will create our safer communities, and they're telling us what judges are willing or not willing to do, right? And so that is part of why it is that we wanted to build up Rate My Judge, a platform wherein we would be able to empower community members to expose what their experiences were in courts, and to really uplift, you know, the experiences that are often just shrouded in secrecy. So we launched RateMyJudge.LA. It is a revolutionary community driven tool of judicial accountability. It's a free, accessible website for community members to submit completely anonymous reviews of their experiences in courts. And we, you know, galvanize and help people to, you know, understand how to use it, to understand that it exists by doing outreach in front of courthouses, you know, and really just explaining to people, you know, hey, approaching people saying, hey, are you appearing in court today? And, letting them know that we would love to hear about their experiences, and particularly if a judge is making a pretrial determination, especially around bail, we have, data within the app to track, a judge's compliance with the Humphrey decision that Justice Collins and others touched on earlier today. And right now, at this moment, Rate My Judge is limited to the LA County Superior Court. So it has a profile for every single judge, which is over 500 judges in the LA County Superior Court, who we're working to build it statewide so that it would be available in each of the superior courts, and potentially be, again, a tool that we could also use to assess, justices in the future as well. And who is the website intended for? As I mentioned, community members are truly the heart of who it is that we're targeting, but obviously we know that the repeat players, the attorneys, the public defenders, the private counsel, those are the repeat players who truly are able to give us a bird's eye view of just generally, how a judge behaves in chambers. And so we really lean on outreach to public defenders, alternate public defenders, court staff, interpreters, social workers, just all manner of people who are working within the courts to just help us to get a better understanding of how it is that the judges who are elected and appointed in the LA County Superior Court are treating folks. And so it collects qualitative data so that we're able to extract anecdotal data, because the person is able to not only provide this star rating, but able to provide us specific indications as to what was informing their rating. And so often, and it's really important to mention that it's not like Twitter, right? You can't just post a rating and it'll just pop up. We have a review team that works with counsel to make sure that we aren't, kind of disparaging folks and not, making any kind of ground baseless claims or anything like that. We also want to protect anonymity, right? So we make sure that, the reviews do not kind of indicate, the defender do not provide any kind of indication as to, the case number, et cetera, things like that folks sometimes would like to sneak in there. So we just really try to highlight the judges' demeanor, the rating score and things like that. So what the information that the site collects is the email and the password. And again, not seeking any name or any kind of identifying information, really being aware of the possibility for retaliation, given that this will be public in the future. And then the person provides their rating and the review. And then there's a further question with respect to pretrial data as to whether or not the judge set bail and what considerations the judge kind of named in the determination of the bail amount, if any. Excuse me. And so in terms of what community members are rating their judges based on, it's around demeanor, sensitivity, neutrality, fairness, and lawfulness, right? In our experiences so far, after Humphrey came down, it has been a ubiquitous experience in our court watching. So in addition to the Rate My Judge program, we partner with an organization in LA County called Court Watch LA, where again, community members are court watching and really kind of surfacing experiences that they're seeing in the superior courts. So folks utilize those. And so it's a really, both with that and the questions around Humphrey, it's a really good way for us to really understand kind of the state of pretrial in LA County Superior Court, how judges are kind of conforming to the law specifically around Humphrey, and even the directives that DA George Gascon has implemented in LA County, making sure that judges aren't just kind of doing what they want, but are conforming to the law as it is in LA County. And again, the pretrial example is a really marked, clear, the through line is really straight as to why it is that community members in LA County who are really frustrated that community demands around pretrial justice were not being heard, and seeing that judges were a prime roadblock in that, we really understood that we needed to organize and we needed to get active within the judiciary for judges to really understand that community members are watching. Right, but there is also a lot of different things just kind of politically salient for us right now as a woman. I understand that Roe v. Wade, and its reverberations are just yet another example of the ways in which the judiciary is a political project. Right, we understand that part of what how we got from the Constitution saying something different between Roe v. Wade to, to the decision in Dobbs. The Constitution did not change. It was the personnel, right? It was personnel, it was demeanor, it was kind of the kinds of frameworks, it was the principles of judicial interpretation that changed, right? And that was a political project that happened in state houses. And that was through coordinated state level strategy in legislatures to make sure and to gerrymander in a way that secured power in a certain way, such that Republican governors were able to appoint judges, right, who were then willing to, and also understanding the federal strategy, right? You know, who takes the presidency obviously matters for who's appointing federal judges, right? And so we were able to see how the perfect storm in terms of what was happening in the political sphere, right, implicated what happened in terms of our constitutional rights around reproductive justice, simply because of the personnel that was moving, and understanding that, you know, state ballots, down ballot elections, you know, in terms of the governor's race, in terms of, you know, Superior Court races, in terms of state retention elections, that all of those mattered for the kinds of precedents that would affect all of our lives. And, you know, again, just mentioning, besides the retention elections, besides, you know, the LA County Superior Court level elections, we're also just raising awareness around the kinds of other positions on the ballot that will implicate other issues that people really deeply care about in their everyday lives. So really understanding that the DA's race is essential, the Board of Supervisors is in LA County, you know, the legislators, making sure that folks are voting in the governor's election, et cetera, right? Really understanding that the ballot really, and our legal strategy has to go down ballot. And, you know, one of the things that we're doing is also really raising awareness around the LA County Superior Court elections that are going on right now. Of the 6 candidates who are going to be on the ballot for the LA County Superior Court, 4 of them are public defenders, and 1 is a civil rights attorney, folks with progressive backgrounds, right? So, you know, we've been doing, you know, voter resourcing, and we also, you know, provided some political education, whether it's in outreach events, things like that, to just provide some clarity around like the demographics in the Superior Court as is, and why it is important in terms of, you know, the kind of demeanor, the kind of perspective that the judge has in terms of what their background is. It very much does matter whether it's a man or a woman on the bench. It very much matters, you know, the racial demographic of that person. You know, it matters in terms of whether or not that person identifies as LGBTQ, you know, because those perspectives, you know, we understand that law is a social project. It's a project of power. And the more people who actually hold that and being able to apply the law in a way that, you know, expands and not contracts who has access to their rights, who has access to the freedoms that are enshrined in the Constitution, really helping people to understand the through line between the backgrounds of folks on the bench and kind of the policy outcomes that we may be, you know, kind of straddled with. So a lot of our work right now is around demystifying the ballot. We provided, you know, a really thorough analysis of every single role on the ballot, just so folks understand what that role does. You know, like what is a city controller? What does that do, right? And so really helping people have, you know, a clear analysis of, you know, what they're being asked to vote for. And then, as folks have mentioned over and over during this forum, when it comes to state state retention elections, and when it comes to the Superior Court races, often folks don't know who the names are on the ballot. And so La Defensa has, you know, done, you know, an analysis of this Supreme Court justices, as well as the Courts of Appeals justices for the district, for the 2nd district, providing some background, providing some just helpful, just condensed information, right? All of it's publicly available, but all of it's not publicly available in one place, right? And so the you know 10 hours that I did in investigating everyone on the ballot and being able to put that all on one web page for our community members to really understand who they're saying yes or no to, you know, that for us, you know, it is a value add and really empowering people. ahead of the elections. So with that said, that was the overview of our app, Rate My Judge, and some of the information that we have on our website for voter resources. I'll go back to that link, and once I stop sharing screen, I'll drop some links in the chat. So yeah, and I think, yeah, let me make sure it stops sharing. No, let me share this one last piece. Are you able to see this Vera Institute document?
It's very small.
Very small. Okay. I think one thing that, in the midst of the bail conversation that the justices were having, I think it really kind of, it just reminded me that we need to really have a clear conversation about what that means for Black and Brown folks around pretrial, right? Because, as of October 2022, this year, right, Vera Institute has done an analysis, and, of making up 8% of LA County, Black folks make up 30% of the folks who are held pretrial in LA County right now, right? Hispanic people being 49%, are 54% of the folks being held in LA County right now. And as I mentioned, you weren't able to see the physical check, but I paid $200,000 US for one person's freedom in 2020, right? In Alameda County paid $555,000. The bail amounts in LA County are extraordinary. The bail amounts in California are unconscionable. And so it's really important for us to understand, that the price on our head, are just inconceivable. And the means, and that's why people are being held pretrial, and that is, it's a means of coercion, right? The trial system as it works right now would grind to a halt if every person that is held pretrial demanded a jury trial. The way in which the people are coerced into accepting pleas that are not in their best interest is because they're being held pretrial, right? And the mechanism of bail, as a sole, decider, means that Black people and Brown people are particularly the ones who are going to be held indefinitely. And that was particularly also why it was that risk assessments were unacceptable to us as well, because pretrial, knowing that pretrial incarceration is not punishment, it's just holding you to ensure, the adjudication of the case. But there are certainly so many other means for making sure that somebody returns to court, right? Including court reminders, including transportation to court. There are other, alternatives to incarceration that will ensure the same outcome, which is return to court. And so it's just really important for us to really have a clear-eyed analysis and really press back against judges who, yes, are experts, but we understand that lived experience is the best expertise, and the kinds of outcomes that are going on, and the racial implications and the racial disparities, mean that it's us, people like us, Black and Brown folks, languishing in cages in ways because of dollars and cents. So yeah, I'll leave it at that.
Thank you so much, Ms. Rasaki. But now I need you to really quick. You said that the app. Okay, so what I didn't catch is the app is actually live right now for use, correct?
Yes. Yeah.
Okay, and so you said it's Rate My Judge.
Yeah, and I'll drop it in the chat. It's ratemyjudge.la.
Ratemyjudge.la.
Yep. So
okay.
Here. Oh, I apologize. There's an X in front of it. What did I do? Okay, so that's it for real. And then for our voter resources on our website, I want to make sure folks also have that. And so I'll drop that in the chat,
So it's ratemyjudge.la.
Yes.
Okay,
My
very good.
website is ladefensa.org. Dropping it here in the chat. And so, the link to the demystifying the ballot resources there, we have in here is our just general voter resource, letting folks know about important dates that are coming up, where the polling locations are, et cetera.
Wonderful. Thank you so much for that information. We appreciate you being here. And with that being said, I'm going to turn it over again to our illustrious, I can't say it enough, our illustrious president, who has some final words for you all, Dr. Carmen Downs.
I did pay her to say that. I know we've had some of our justices drop off, but I know one thing that I've observed this evening is that it's truly a circle of individuals who respect one another. So Justice John Shepherd Wiley, thank you for joining us. And please also thank for us Justice Audrey Collins and Justice Baker. We really appreciate you all taking time out of your, what I'm sure is a very, very busy schedule. I just really want to emphasize we are a nonpartisan organization. We extended invitations to multiple candidates because our goal is to ensure that we impart knowledge to our community. So again, thank you. I also really want to thank La Defensa and Ms. Wasaki. I hope I pronounced your name correctly. You always drop so many nuggets of knowledge, and we appreciate your time as well. Also, we wanted to thank our partner, Southwest College Foundation, as well as the students there for attending. And I we could not have done this without our outstanding Public Policy Committee. They can do this with their eyes closed, and it's such a benefit to the community and such a benefit, I think, to all of us. So thank you, everyone. Did I touch all the bases?
You did. And just as a reminder, on Monday, October 24th, we're having a part 2 of our 37th Congressional District Candidate Forum featuring Jan Perry, who was unable to attend the first event, but is able to attend on the 24th. And so that information is on our website. And tomorrow, we are partnering with the National Council of Negro Women for a Propositions Forum, which you can also find that too on our website. Dr. Downs, that is all.
Have a good evening, everyone. Thank you so much for joining us.
Thank you. Thank you so much. And if just the committee can stay on, we greatly appreciate it. Thank you, Justice Wiley.
Thank you, Justice Wiley.
Thank you, Ms. Rasaki. I'm gonna be calling you in the next couple of days. Thank you all. Have a great evening. You can stop the live.